Okay, thanks. Oh,
I think we lost
oh
Courina.
no.
Oh, yeah.
Hello, everyone. Thank you for joining. We are still having students and attendees coming in, so we'll be waiting, and we just lost one of our panelists, and she just came back, but we will be starting very soon. And in the meantime, if you can, if you could turn on your camera so that we can all see each other and the panelists can see you, that'd be great.
Feel free to use Zoom's reactions if you guys are particularly impressed by some of our explanations about what bankruptcy law is.
Okay, so in the interest of everybody's precious time on a Tuesday evening, I think we'll start right now. So hello, everyone. Welcome to What Do Bankruptcy Lawyers Do panel, co-sponsored by AABANY's Bankruptcy and the Student Outreach Committees. My name is Sharon Yang, and along with my colleague Charlene Hong, we are co-chairs of the Student Outreach Committee and co-moderators for today's panel. Today, we are super excited to have 4 amazing panelists with different backgrounds within the broad practice of bankruptcy and restructuring to share a little bit about their path and advice to our students. So to kick things off, we want, can each of the panelists give a high-level, non-technical introduction about yourself? And I'll start with Patrick.
Okay, sure. Hi guys, Patrick. Born and raised in Jersey, I guess. I graduated from law school in 2017. Got to Columbia, did 4 years at Aiken Gump doing financial restructuring, aka bankruptcy. And then clerked for a year for bankruptcy judge in SDNY. And now have been at Morgan Stanley in-house, sort of, not to be too technical, but working on the debt side of the business for the past few months. I guess I'll pass the ball to Jacqueline.
Hi, I'm Jacqueline. I am currently clerking for Judge Lane and SDNY and clerked for Judge Drain the last year. I went to SMU Law School in Dallas, graduated in 2020. Before clerking, I was working remotely at home for a small law firm because I went home to California during COVID and also graduated during COVID. But yeah, born and raised in California, found my way to Dallas. Now I'm here in New York. Now pass it to Annie.
Hi, I'm Annie. I am currently working as a trial attorney at the U.S. Trustees program. Prior to that, I had spent several years clerking for several judges in the Southern District of New York. And before that, had been in private practice at various firms in New York City. I am a graduate of Fordham Law School, early 2000s, and I'll just leave it at that.
Hi, everyone. I'm Courina Yulisa. Currently, I work with Dorsey and Whitney in their finance and restructuring group within their bankruptcy practice group, but I do a little bit of lending transactions as well and litigation. So before Dorsey, I clerked for a bankruptcy judge in the Eastern District of New York, Judge Elizabeth Stong. And then before that, I actually didn't practice law for a number of years and did nonprofit management work. I graduated from Brooklyn Law School and spent about 3.5 years doing consumer bankruptcy and small business Chapter 11s right after law school before I went to do my nonprofit work. And now here I am.
Wow, thank you all so much for sharing. And I, just from the 4 of you, I can see that you all come from very different backgrounds. So I guess I'll start with Courina. Can you tell us a bit about what's the difference between bankruptcy and restructuring? And you mentioned litigation, you mentioned bankruptcy, lending practice. Can you do both, or can you do, how many different aspects of this broad umbrella practice can you do as a law firm attorney?
Well, I think this is what makes bankruptcy so exciting and interesting, is that you get to do a whole lot of different things. I would say, in my opinion, that bankruptcy is the proceeding, and specifically court proceeding, for restructuring, right? It's one method of restructuring a company or an individual's assets, whatever it is. So restructuring is the bigger umbrella, as well as reorganization, as to how you restructure a company, reorganize the company, so that they get out of their, financial difficulties. So within that umbrella, obviously the practice has a lot of different facets to it. It can be transactional restructuring or out of court restructuring and workouts. It could be, lending transaction refinancings, right? It could be the bankruptcy court option, which is the Chapter 11s, the Chapter 7 liquidations, even the Chapter 15s, the Chapter 9s. There's a lot of chapters in there. So I think there's a lot of avenues within the restructuring world, and the bankruptcy avenue is just one facet of it. And I think associates, especially junior associates, kind of get thrown into a little bit of everything. And then as you progress through the years, you kind of specialize, if that's, how the firm works for you guys. And then you kind of end up, having a minor and a major, at least in my experience. So, my major is definitely bankruptcy litigation and bankruptcy cases, but I also do lending transactions and deals as well. I do regulatory affairs work, dealing with financial transactions, and I also do litigation as well, all stemming from my bankruptcy experience, which is great. I don't know if anybody else would like to jump in.
Oh,
All
that
right.
sounds amazing. So, more than one of our panelists here today have had clerkship experience. So I want to direct this question at Jacqueline, but, other panelists, please feel free to jump in and share your insights. But Jacqueline, can you tell us what, on a very basic level, is a bankruptcy clerkship?
So a clerkship generally is a postgraduate opportunity to work for a judge. Bankruptcy in particular is very much like any other federal clerkship, at least from what I've heard from other friends who have done district court clerkships. Generally, they just function the same, kind of the roles and responsibilities to an extent are the same. And similar to what Courina has said, bankruptcy is very much an umbrella. And so when you're in bankruptcy court, I think a misconception is you purely deal with just bankruptcy law. And I think what people think about is probably Chapter 7 liquidations. But when you're in bankruptcy court, you actually touch on a lot of things that I think law students right now have had classes on. So like property, contracts, various other things. But that's the general gist of a bankruptcy clerkship. But I think the other panelists have also clerked. So if anyone else has things to add, feel free.
Yeah, for sure. I mean, kind of touching on Courina's point, bankruptcy is kind of like the court-facing part of restructuring, right? So when, all things fail and they're not able to negotiate a solution that avoids like the cost and the public exposure of going through bankruptcy, then you start litigating in bankruptcy court. But it's not always purely litigious. A lot of it is deal making in bankruptcy. So it's like part kind of civil litigation that you're doing a lot of procedural stuff, all the discovery related stuff, and motions to dismiss, summary judgment, and the like. Then you touch on a lot of transactional stuff, which is very cool to see as a clerk. And you especially see like a lot of cases go through of different sizes. You have, maybe a restaurant in Soho that filed for bankruptcy, or some dental clinic up in like Washington Heights or something like that. Or you'll have like FTX end up in front of you. And that's like entirely different type of case. So it's really cool to see basically a cross section of just, how the economy is doing, what kind of like legal and also business issues that basically the whole economy is facing, especially coming from, if you're in New York, but anywhere really.
Yeah, and reading Wall Street Journal now sometimes gives me heartburns because I see all of these companies, the prospect of a potential recession and all that. And I kept thinking about how for bankruptcy attorneys that I don't know if it's if it's a good comparison, but it's a boom season, I guess, for bankruptcy attorneys and bankruptcy courts. And turning to another aspect of bankruptcy umbrella practice, I guess. Patrick, you are currently in Morgan Stanley. So can you tell us a bit about what do in-house roles look like for bankruptcy attorneys?
Yeah, I mean, it varies. I'll start with like what maybe my job isn't and what in-house positions could be. When you're a bankruptcy lawyer, you kind of learn how to sort of quarterback a company through restructuring if you're representing a company. And if you're representing, the banks or the hedge funds at the or the landlords or anybody else that the company owes money to, you're kind of on the other side of it, right? But you are working with the company through all sorts of legal issues, including bankruptcy, but also other issues such as, property, tax, intellectual property, labor, corporate, like M&A, blah, 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 everything. So you kind of learn how to overall be like a true counsel in the sense of the word to companies. So that allows you to basically pivot into being an counsel for just a general company. I know a friend of mine who went from restructuring into being like counsel to a crypto company that subsequently filed for bankruptcy, but like a few years later. So they were very lucky to have her. It turns out. So that's one way that in-house roles for bankruptcy attorneys can pan out. Other one is that if you are looking at a financial institution like Morgan Stanley or another bank or like a hedge fund or anything else, they need people who can help basically do all of this like distressed debt trading, can help with like structuring all of this, basically think about ways that you can think about ways that you can basically use the bankruptcy law and everything else to basically the benefit of your like firm strategy. It's a little bit like there are in any particular like business, you use external counsel for particular transactions, but you also use internal counsel to evaluate not like how to do the transaction, but whether you should do the transaction. It's a little vague, I guess, but I mean, basically you can use your bankruptcy expertise to be in basically finance on the legal side.
I see. And I guess a follow-up question to you, Patrick, is you mentioned that you have friends who jump to a crypto company to become a counsel. Can students go directly into a role like, the position you are right now in? Or do students usually have to go to firms to become bankruptcy attorneys first and then go in-house?
I think you basically have to be in a firm or, maybe I think you have to be in a firm first because you have to learn how to actually operate a deal first. You have to understand the credit agreements, the plan disclosure statement, and just all sorts of other, like, parts of a bankruptcy transaction or a restructuring of a company. Once you understand the nitty-gritty, then you can kind of be in a position where you're working together with the business people on your team to evaluate, like, how a transaction is going, whether you should maybe like invest in the transaction or not, or whether this transaction might implicate like other areas of the company if you were to like carry it forward, like for tax reasons or something like that. Just higher level stuff. You need to understand the lower level stuff first, I guess. Then the more nitty gritty stuff, I guess.
Thank you. And I guess turning to you, Annie, can you explain to us what work does the U.S. Trustee program for the DOJ do, and what's your position in the program?
So I said earlier that I am a trial attorney. The U.S. Trustees program is a component of the Department of Justice. So that's, I guess, the executive branch as opposed to working for the courts, which is the judicial branch. And the program is responsible for overseeing the administration of bankruptcy cases and private trustees, meaning the panel of Chapter 7 trustees, the Chapter 13 trustees, and sometimes Chapter 11 trustees under specific statutes, which is 28 USC 586. And I think there are also certain provisions within the code itself, which is 11 USC 101, that lays out specific functions reserved for the U.S. trustees. The program is national, and we have, I guess, broad administrative, regulatory, enforcement, litigation type authority to the official mandate, if you go on the website, which is the easy cheat, is to sort of promote and maintain the integrity and the efficiency of the bankruptcy system for all stakeholders, right? So I guess one way to look at it is if you're working at a firm and you're doing a lot of debtor work, you're looking at it from the perspective of, the debtor and making motions for the debtor. Whereas if you go, maybe there's some firms that will specialize in like committee work or do a lot of creditor side work, right? So that gives you a different perspective. The program is not any particular constituent, but really to look out for all stakeholders. So creditors, debtors, and I guess there's also sort of a general sort of public interest component as well, including, for example, like the SEC, right? So you may have policies or laws that are being made that'll affect public interest. I think what that translates into in terms of the broad mandate for sort of day to day. So the enforcement part is really three parts, right? So the litigation part is you'll see us when you're in bankruptcy practice, you'll see the trial lawyers go into court when a case files, we may be filing objections, we may be making motions ourselves. And that's the judicial sort of litigation process, right? We may take a position with respect to some particular motion that a debtor or a creditor has made. A typical example may be something like, bonus programs like a CURP, right? And so what'll often happen is parties may want to look for payment for management, and there may not be any particular constituent who has an issue with that because, management wants to be paid, so the debtor wants to relieve, and maybe the committee is on board. But the U.S. Trustee's office will come in and say, hey, look, as part of ensuring that the code is complied with, right? Have you met your standards? Have you met sort of the legal burden to ensure that you're entitled to the relief that you're seeking, right? And so you'd be looking at, whatever, Section 503, for example. So that's one way in which the mandate is carried out, which is through litigation in the courts. Another way that it's carried out is through the administrative functions. And I mentioned earlier, for example, overseeing trustees, right? So when you have, in the smaller cases, Chapter 7 panel trustees that are appointed, our office is responsible for overseeing them to make sure that they're doing their work when they're administering estate assets and looking into those cases and monitoring and supervising those cases. We then turn around and supervise them. Similarly, for the judicial aspect of it, I was actually reading up on this case. I think it's Siegel versus Fitzgerald, which actually gives a little bit of history. So right now, I think there are 21 regions that the country's divided into, for which serves or falls under the U.S. trustee program, but there are two regions, two states, North Carolina and Alabama, where there is no U.S. trustee program, and they are governed by these what we call bankruptcy administrators. And the whole point of the case is the difference between how the fees are assessed, because the U.S. trustees program funding comes from a separate line, and then the bankruptcy administrators who actually their funding comes from the courts, which is back to that executive branch versus judicial branch. And so originally, many iterations ago of our bankruptcy laws, the courts, for example, were responsible for appointing Chapter 7 trustees or just trustees to oversee these cases. And for efficiency and other types of reasons, that got delegated to the U.S. trustee program so that we take some of those functions away, right? Other administrative functions, for example, appointing a committee. So only the U.S. trustee is charged with forming an official committee when a case gets filed. And then lastly, the enforcement part is probably something that most people don't see in the courts, and that takes place sort of on the outside, meaning if we're looking at, for example, we see something in a bankruptcy case where there's a party, sometimes it's the debtor committing what we think may be tantamount to bankruptcy fraud, right? There's the criminal enforcement aspect of it, and we may coordinate our efforts with the U.S. Attorney's Office or the FBI into investigating, is the debtor secreting assets? Is the debtor, hiding something? Right. So the theme that we're always focused on, regardless of what role we're in, is transparency, right? Because unless everybody knows what's going on, it's very hard to monitor and to know if something is wrong if there's no transparency in the process. And the civil enforcement aspect is similar, just not criminal. So, we'd be looking, for example, to see that debtors who are in bankruptcy are eligible, right? So the means test is one way of ensuring that when someone files for 7, for example, they really should be in 7 and not, for example, in 13. So those are sort of the categories of tasks in which we're able to carry out a mandate of sort of overseeing cases, monitoring, and promoting the bankruptcy integrity of the bankruptcy system. That's a mouthful, so I'm going to stop so we can stick to the time.
Thank you so much for sharing. So I guess diving a bit deeper, I want to go back to Jacqueline, but all the other panelists, please feel free to jump in as well. Can you tell us a bit more about, I guess you already touched upon it a bit, but what are the core responsibilities, as well as, a typical day, or maybe there's no typical day, but what's your day-to-day and your core responsibility as a bankruptcy clerk like?
So I think there are probably 2 core responsibilities. One being preparing the judge for hearings. So Judge Lane right now, for the most part, has calendar days Tuesday through Thursday. So the day-to-day would be preparing him for however many hearings he has, and those hearings can be anything from a status conference to a contested motion to dismiss, for example. So depending on what he needs, it could involve creating a bench memo and doing legal research, or it could just involve staying up to date with certain cases. My experience with the judges that I've clerked with the bigger cases, you usually split up these cases amongst your co-clerks. So not one person has all of the mega ones. So each person is kind of responsible for keeping up to date with what's going on with some of these bigger cases. So in those situations, when things are filed and motions are coming up or hearings are coming up in the next month or so, you're responsible for letting your judge know that, hey, this might be a heavier lift. You're also responsible for reading through everything. You're kind of the first person your judge will go to give a rundown of what's going on. So even though the judge will read through everything and you'll work with the judge in figuring out what decision he or she should make. Oftentimes, at least for me, we will usually go into like a pre-discussion, right? So we'll go through kind of what's coming up, and I'm the first person he'll ask, what should I know? Like he'll go, just tell me generally what's going on. So that's one piece of it. The second piece is decisions. So that could be anywhere from helping him or her write a bench decision to writing an actual opinion. So depending on the matter, Judge Lane will either take a matter under advisement and decide that it does not have the complexities that he thinks it warrants an opinion. And so instead, he'll write or I'll draft a decision and then ultimately work on it with him that he will just read into the record. So these decisions are not necessarily the ones that you'll be able to find on like Westlaw or Lexis. And they differ to an extent to like the longer ones, longer opinions that you would be able to cite to. So I think those are kind of the two core responsibilities. As a clerk, you're also just the behind the scenes team for your judge, and you're really working with either one or two co-clerks and the courtroom deputy, and that's pretty much it. And you're the team that is kind of, I guess, the barrier between the outside world and the judge. And so your role could also include administrative stuff. Some judges are totally fine with their clerks interacting with attorneys or everyone else. Other judges don't like chambers interacting with other attorneys except for the courtroom deputy. It just really depends. So depending on who you clerk for, you kind of just learn what they like to do in chambers. But I think that's for the most part, the responsibilities that clerks have. I don't know if anyone else had a different experience or anything additional.
No, I would just add that I think the cool thing about clerking compared to being at a firm is that, you know, at a firm, you're just kind of zealously advocating on behalf of your client, whatever result, trying to basically win as many dollars for your client as possible or avoid like liquidating or whatever it is. And when you are clerking, you're basically, instead of trying to zealously advocate, you're basically trying to figure out what is the right decision. Mm-hmm. What does to the principles of truth and justice provide for, or moreover, the bankruptcy law.
Well said.
Thank you.
And I would also add in terms of writing styles, like it's interesting the difference when you're drafting an opinion in chambers, it's very unbiased, you know, it's not picking a side. And then when you're in a firm, you have to be persuasive in terms of your writing for a particular side. So that's also an adjustment.
Thank you all for sharing. I guess the next question directed to all of you is, what do you find to be most rewarding as well as most challenging about what you currently do? I guess I'll start with Annie.
I bet my answer people have not heard before. I find rewarding the people that I work with, and generally both when I was on the court side and now at the U.S. Trustee, and even in private, the bankruptcy bar, especially at the, you know, when you're dealing with mega cases in the bigger firms, are high caliber attorneys who are very smart, and they're paid not only, you know, to be able to draft well and advocate, but also to strategize, right, and negotiate. And again, it goes to sort of understanding what your client's needs are and crafting solutions for people within the confines, right, the structure of the code and what you can do. And even as a trial attorney for the U.S. Trustee program, I have a client. So I think people think of government as sort of public interest, but my client is the United States Trustee, at least for my region, right? And so we do take positions, going back to what I was saying before about you might see us in court with X, Y, and Z, and it may be kind of a program-wide policy, or maybe something very specific to the case that we're looking at. And so we do advocate, and that also requires, exercising discretion and implementing strategy to make sure that we, win, right? That we prevail on whatever position that we take. And in terms of what I find challenging, again, it's sort of also the theme for bankruptcy is because it is so sort of all-encompassing in terms of the breadth of the subject area, right? You could be dealing with employment law, you can be dealing with contract disputes, right? That even with judges, even people who have been, practicing 20 years, right? There's always something new and exciting to learn, because you just can't know everything all the time, or the law changes, or there's something like cryptocurrency, which, wasn't around before. So what's exciting and challenging is that I always feel like I'm learning something new, and I feel challenged even though I've been at it for 20 years. Okay.
I'll echo definitely the exciting part of it is like learning everything. I'm definitely a very curious guy. It's not only is bankruptcy law very, very like deep, but you just pick up not only just like other areas of law, and you're not doing everything, obviously, especially if you're like a large firm, you like loop in, your litigation folks, your, environmental folks, blah, 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 but, or like your foreign law experts, but you tend to learn about the particular industry, the particular issue while you're going through it. And, yeah, I think that's really cool. And I think that also you are kind of working with and helping people. Again, especially if you are working with the debtor, the person or the corporation that's filing for bankruptcy. You kind of are like, helping them solve this problem that might not always be their fault. It might be because the COVID pandemic hit, or if you're like I don't know, variety of reasons, so that's like kind of nice part about it, I think, compared to maybe some more corporate transaction groups. I mean, undoubtedly bankruptcy dwells in like the area of like, oh man, like everybody's a little unhappy, but it's kind of nice to like work with people in this space too, rather than just like, yeah, let's go like raise a bunch of crypto companies and who gives a shit.
Oh, no, go ahead.
Okay. Well, I would definitely agree with Patrick and Annie. And then just to add to that, I love just the whole, I can be doing something transactional in 1 hour, and then the next hour I can be working on litigation matter, and all kind of like within the same case sometimes. And I think that keeps it interesting, and you don't get into the same day-to-day routine. I also love the fact that there's just different sizes and different demographics. I did consumer bankruptcy before, so it was really helping out the individuals, people who were, who lost their jobs, and people who got hit hard by the recession or foreclosure crisis, those types of things. And then I could also be working on, like recovering, $500 million from a debtor or creditor, or whatever it is. So I think that diversity is a really interesting aspect, and what makes bankruptcy unique also, and what confuses the firm management here, the administrators, are that we are both transactional and litigation, and they never know where to put us in terms of our trainings.
For me, I think I really do love learning new things every single day. Going into court, we just get just new things coming in, and it's a new area of law that I don't really know, and I think it's been a lot of fun, and I'm very grateful that I've been able to develop these relationships with these judges, because I think that's another thing I love about clerking, is just being able to sit down with your judge and be able to discuss some of these really nuanced issues. And it really just kind of pulls down this barrier, because before clerking, judges were quite scary to me. And so now being able to have some relationships with these people, I think it's been really great. And then for challenging, I think Courina touched on this, but when I first started clerking, I didn't really know how to be unbiased. So learning that was an incredible challenge. And it's 100% true. When you're clerking for judge, you really need to present both sides, at least to him, so then he can figure out like which way, like what is the law, like what's the right thing to do here. And I think we've had a couple of cases where there might have been some bad actors, but according to the law, it should go a certain way, right? And so like dealing with those things, it's definitely a weird feeling. And I think that is definitely something that's challenging, at least from the clerk perspective, that I often still work through.
Yeah, and I forgot to mention challenges on my end. I think one of the challenges of bankruptcy is that it's pretty fast paced. And that's because, obviously the company is like running out of cash. And so you need to get a deal done as soon as possible, before, all of its like vendors disappear, all its employees disappear, etc. So yeah, that's like, I would say, something that you have to get used to, kind of like, as we've alluded to so far, wake up every day expecting like a new fire to happen. But the upside of it is that you're spending your hours like doing this, driving deals forward quickly, and not really devoted to some of the drudgery that goes into like, years long like matters that you might be exposed to in other practice groups. Yeah.
Great, thank you, panelists. It's super interesting to hear what's so rewarding but really challenging, and how that differs across all of your different roles. I think it's really great also that we have panelists that are sort of in a different context of bankruptcy work for each of you. So it's really interesting. We get to hear it from all perspectives, from private practice to public interest, of course, also the bankruptcy clerkship context, and then in-house. And I think this next question, and this next set of questions rather, are all going to go more towards understanding the culture of bankruptcy, and then seeing if any of the law students who are in the audience today, if this might be the right fit for them. So I think the next question I have is going to be directed to Patrick and Annie, especially since both of you work in the in-house and the government context. What kind of working styles have you found you maintain in your roles, and how does that potentially differ from the working style you may have had in private practice? And I guess, Patrick, if you could go first, and then we can go again.
Sure. Working style. I think you have to be very organized. To my point earlier, you have to keep a track of all these threads that are simultaneously happening, right? And understanding all the upcoming deadlines, because just to put it more concretely, in order to confirm a plan, which is basically the bankrupt company's exit plan, to like basically successfully reorganize, you have basically a month to decide for parties to object and litigate. And if you have a larger civil litigation, that might be more like half a year. So you just want to keep on top of everything. You have to be organized. Working style, flexibility, communication. In every particular bankruptcy, you have multiple parties involved, including at least the company, at least the creditors, like Morgan Stanley might be one. U.S. trustee, of course, you have to make sure that you never annoy Annie too much, because just, if she's upset at you, it's going to be very hard, very hard to get this deal done. Yeah, so you have to be good at basically being interpersonal and keep on top of things and negotiating with multiple parties at once. And I guess in terms of in-house versus private sector, I probably haven't been here in-house long enough to truly understand what it takes to succeed. I look forward to finding out. But I think it is being able to see sort of kind of people's motivations for doing what they do, like you know, deciding to invest in this piece of debt or that piece of debt, or deciding to employ this litigation strategy or not, so you can anticipate further down the line what will happen. Basically, I think just because I've like been in a law firm, I've been clerking, now in-house, the way I would think about it is that, you know, starting from the bankruptcy court, that is where all messy disputes end up. Like what all the culmination of all these years of actions have resulted, and you fight it out there. Law firms are where you kind of like, you know, etch together, you know, all those transactions that resulted in this like structure that you're fighting over now in court. And then when you are an in-house attorney, often you are trying to view, like, forecast into the future what all of the people's moves might be, so you can plan ahead and figure out like how you can start setting up your client to succeed. Like basically, are you going to engage counsel? You're going to get in on this, you know, this transaction or not, and how? I think that's kind of the way I describe it. So you have to be very like high level. And, yeah.
Thank you. That was really thorough. Annie, do you have any additional perspective?
That was thorough. I would say the same things, but maybe how they play out is slightly different. So, you know, going to something Jacqueline had said earlier, which is, you know, when you have a client and you're thinking from the advocacy perspective versus when you're for the courts and you're just thinking of getting to the right results, the U.S. Trustees program is kind of in the middle, because we're justice, so we're always right and we're always thinking about doing the right thing, but at the same time, you know, there's also still just our own position. The position also being, you know, looking to sort of public interest, if you will. Another funny thing about the U.S. Trustees is, you know, one of the calculus that we don't really have compared with when you're at a firm serving a client, or when you're at the client and you're in-house, is like cost, right? So when you're thinking about litigation or strategy or what you want to do and hiring counsel, right, there are monetary consequences to doing all of those things, including whether you win or lose, and what is it going to take to get you there to some result, right? So thankfully or unfortunately, I don't know, depending on how you look at it, right? I think when you're at the government level, you're not really thinking about, oh, you know, am I going to have to pay my lawyer $2,000 an hour, you know, to go do X, right? So that's not something that we consider. So those are kind of like the little ways in which I wouldn't call it style, but I think what you're thinking about differs in terms of how you practice, right? And what your focus and your priorities are, depending on, you know, what side you're representing or not representing.
Absolutely. I definitely agree that strategy is going to determine sort of how best you practice and work with others. So that completely makes sense. The next question I had was also, I think, targeted towards particularly law students who might be interested in the area of bankruptcy. So Jacqueline, I was wondering if you could tell us how you knew that bankruptcy was the right fit for you and how you ended up entering this path.
So my path was a little different. When I started my first bankruptcy clerkship, I actually had never taken a bankruptcy course and knew very little about bankruptcy law, except from my husband, who is also a restructuring attorney. And at the time, I didn't know the difference between a debtor and a creditor. And so I went into the bankruptcy clerkship, just super ready to learn, but also like just no idea whether or not I would come out of it wanting a career in bankruptcy or wanting to be a restructuring attorney. Within the last 2 years, to my surprise, I actually have developed an immense interest in it. I think primarily because of what everyone has touched on. It's not such a pigeonholed area that maybe the outside thinks it is. Once I kind of entered this space and started learning more about just kind of what can get folded into a bankruptcy, including kind of what types of issues can come up in adversary proceedings, all these different things, I started realizing I think you can do a lot with a career in this space. And so I am still working through it. But I think the last at least year and a half or so has convinced me that I would at least like to start my career in this area and then just figure out whether or not I want to do more debtor work or creditor work or neither and do something else in bankruptcy. I think it's just such a vast world. And so I mean, honestly, it was just clerking for these judges and seeing all these wonderful attorneys come through, all these different cases come through, and these issues that at one point, I think I was working on something related to trademark law, which is just not something before the clerkship I would ever think I would touch. And after that, I was like, oh, well, there are many layers to this bankruptcy onion. So here we are. But yeah.
That's fantastic. And I hope also from the other panelists, you've gotten to learn a little bit more as well about all the different pathways that are out there for you post your clerkship. So I think the next question is really more towards what students can do now to prepare to become a star bankruptcy lawyer. So Courina, I wanted to ask you this question. Could you provide some advice as to what kind of student would make a really great bankruptcy lawyer, and then what kind of person would be a really great bankruptcy attorney later on in practice?
Well, you kind of never know, right? We have Jacqueline, who's never had a bankruptcy course, and she's doing great and she's loving it. And then, I took a debtor creditors rights course, and I took an internship with a judge. And I also wanted to point out there's that list of internship programs that you guys can do that places you, with bankruptcy judges. And I think that's a great way to really get exposed to the type of work that, you're interested in. So I would say definitely, take those internship experiences, those work experiences when you can. Definitely talk to your bankruptcy professors. They have, they know the world. They know the connections, the network, and they can kind of give you a guide as to, where you want to start off and what the market looks like. And then, of course, there are, great organizations out there like ABI, who's very focused on bankruptcy. It's the American Bankruptcy Institute. And CPJ has conferences every year. That's the National Council of Bankruptcy Judges. I'm getting my acronyms tested here. And then there are also, like AABANY, we have the bankruptcy committee. So there are a lot of ways to kind of get involved externally to meet bankruptcy practitioners and figure out if this is the right fit for you. But I think overall, it's, really a willingness to learn. I would say that bankruptcy is industry agnostic. So if you wanted to learn about a variety of different industries and different types of practices, I think bankruptcy could be a good fit for you. And also, I think bankruptcy is also a creative type of business where you're trying to craft different types of solutions for clients, restructuring your debts, asserting your creditors' rights, whatever it is, right? So there are different roles that you can play. So if that's something that you like doing, you're maybe not gung-ho about just all litigation or all transactional corporate work, maybe bankruptcy is a good outlet for you. So those are my initial thoughts. I don't know if anybody else wants to add.
Maybe some drafting classes. There's a lot of drafting. I mean, again, it could either be persuasive writing because you're in a litigation role and you're writing briefs, you're writing motions, or it could be like commercial transactional drafting, right? Doing contracts and loan agreements, right? They can be very dense and very daunting. And sometimes the language gets very convoluted, and you better make sure what you wrote down is, intended to effectuate some transaction in a certain way for your client. Because later on, when other people read it, they won't have any idea what you were trying to do because it's so complex. And even if at the end of the day, you don't go into contract, just having very solid drafting skills, will be applicable in any practice area that you choose. So drafting is very important.
For sure. I'll admit I didn't take bankruptcy law in law school either. Probably should have, but you'll be fine if you don't.
Absolutely. That is definitely well noted, especially about the drafting class. I just wanted to say, since Courina mentioned the internship opportunities, I think Sharon has plugged them all in the chat here, but we wanted to make sure everyone was aware that the last 3 bullet points that were sent are for various internship opportunities that are funded. And then the first one, the Roadways to the Bench program, this is a national program that is providing information about how to become a bankruptcy or magistrate judge. And part of the purpose there is to increase diversity with respect to those benches. So I think the actual program itself will be held on April 3rd at 4 p.m. Eastern time across the United States in terms of the live stream version of the national panel, but there will also be local roundtable sessions that participants can attend and also have opportunity to interact with federal judges. So if that's something of interest to you, please look further into those links that Sharon provided. And I think lastly, we wanted to end this panel with maybe some advice that can be provided by any of the panelists that have thoughts on this. But since this is organized by AABANY, and of course, I think most of our audience members are of Asian descent or Asian American, knowing that, do you find that there is a challenge for API lawyers in the bankruptcy context, specifically in each of your various roles and contexts where you practice? And if so, what kind of advice do you have for the future API lawyers who are going to go into bankruptcy? I know this is a bit daunting. So Patrick, if you might have any thoughts to start off with, and then we can move on to others.
Sure, I'll start first. Yeah, I think, tying a little bit also to what you were talking about just before this with regards to all these opportunities to get involved, especially focusing around diverse applicants. I think diversity is, bankruptcy is not too diverse. I think it's actually, I think it's in dire need of more diversity. And I think when you talk about issues like bamboo ceiling, a lot of that is due to lack of diversity, particularly in the senior level, right? But just all throughout. And so with my view, I understand there's certain stereotypes and connotations behind particularly Asian people. We're like meek, not really assertive, don't really stand up for ourselves. And I wouldn't say I'm an exception to that, but I think that part of it all is just with the bamboo ceiling concept, it probably is just because there aren't enough people like us in the senior ranks that appreciate what we have to offer beyond these sort of mismatches with the culture that the working culture that they themselves embody and then their bosses embody, right? I mean, just think about it. It's not like in Asia, it's not like there are no senior people in Asia, right? They just have a particular working culture, working style that works for them and people get promoted within, right? That's just not really so integrated here in the US yet. But I think it's coming. So that's kind of my view on it. I'd love to hear everybody's views.
Yeah, I can piggyback off that, and it's definitely a work in progress. I do think that the effect is still there, and it's still very prevalent. I go to these conferences, these gatherings, and I am in a room full of white men, mostly. It is changing. I am seeing more and more, female leaders and attorneys of color step up, but it's definitely still a very minor minority within, I think, the bankruptcy bar overall. And, it needs to come from a few different places in terms of increasing it. We kind of need to assert ourselves, but also our clients need to also ask for it. And it's part of their responsibility too, to make sure that they have, they're staffing their legal teams with diverse people, with attorneys of color who can provide different perspectives, with female attorneys, whatever the case may be. So that's still something that we need to promote and enhance. And I think, programs like this help because, it's nice knowing that you're not the only one with a different skin color within the ranks. I think in my firm, within my group, I think there's only 2 Asians within it, and we have a pretty big group. So it's nice to see and to be around Albany folks, to know that there are those attorneys out there who are making it up in the ranks, and also supporting and uplifting others who are law students who are more junior to them, to make sure that they're rising up the ranks too. So I think it's kind of a responsibility that we all need to undertake to make it better. And also just including more and more allies as much as possible, whether it's through our clients, judges. And I know that my judge is really passionate about diversity initiatives. And people who are already in power can they have a way of influencing things. So
yeah, I think I obviously haven't really experienced it in private practice or anything outside of clerking, but most recently going to even like clerkship receptions. It's me, and then I think there is one gal if Delaware is invited. But if Delaware is not invited, then I'm the only like Asian person there. And I think at least going through law school, I think I had to work through a lot of just building confidence and not feeling like when you walk into a room and there's only you and 2 other Asian people that you have to compete for like the only diverse spot. So that's something as law students, I think just working through that is important, because I definitely remember going through that in law school. And then I guess advice would probably be I know you hear this in law school all the time, but like networking is huge. And especially in this space, I think a lot of the opportunities that I've been given, it's because someone has lended a hand, right? And so any of us, I'm sure if someone needed assistance or whatnot, like my judge always asks me for recommendations for or references for people to hire as a clerk. before he like dives into the Oscar list of names or applications. And as someone who's in this position, like, even though it's a small position, but I am right next to the judge and he will take what I say a little bit more than just seeing a name in Oscar. And so I feel like it's just those little things as we hopefully move up in rank or whatnot, we're able to kind of like pass it forward. And so there is hope, but it definitely takes little by little. And so I think networking is a huge thing. I think going to all of these things, reaching out, a simple email, trying to go grab coffee, like those things are actually very real when they teach you that in law school. But it's also maintaining those relationships. One email and never like following up, nothing's really going to happen after that. So the relationship maintenance is pretty important.
Yeah, just, I mean, I don't know if any has any thoughts, but just piggybacking off of that with networking, I think that there's something that we as a culture, maybe of immigrants or children of immigrants, are not really accustomed to, kind of being on the outsiders, basically. But it is a very, very vital and important a part of corporate culture here in America.
So don't be afraid.
Yeah,
Just do it.
Yeah,
You
we all gotta learn.
You can send any of us an email, and then networking also doesn't have to be you in a room with 100 people, right? So like whether it's just reaching out to an Asian American attorney that you met once and emailing them and being like, I would love to buy you coffee. That's like a start. Like it can just be one-on-one and it's not as scary, or it could even be an email back and forth. Like there's so many different ways that you can go about it nowadays, especially with Zoom. And so there are ways about it if you ever wanted to talk to any one of us. We have ideas.
I agree. Yeah, I think we were all gonna just write our emails in the chat, or
I was just about to say, I think the call to action to definitely take advantage of your networking opportunities is a good one to end on, because we just first and foremost wanted to thank each and every one of you for being here. We really do appreciate your time and all the advice and experiences that you had to share with us. So yes, Patrick, I think we did discuss earlier that if the panelists are willing, they could share their contact information in the chat. We'll also use this time to see if there's any questions, but I realize we're also at 7 o'clock or past 7 o'clock rather. So I want to make sure that if any of our panelists have a hard stop, that you are absolutely free to go. And thank you so much again for being here. But if there are any questions, please feel free to leave those in the chat. If anyone is willing to and able to stay over, maybe some of our panelists could answer those questions as well.
or you can unmute yourselves, whichever you prefer.
Exactly.
Or you can email us the questions. If you
So many
in
ways.
front of everybody.
So many options.
Should I microwave some dinner while we wait for questions?
Yes, Patrick, please feel free to do that. I think we have a question from Jay, which is, would you consider bankruptcy a recession-proof field? Patrick, if you wanted to go microwave your dinner, I think maybe our other panelists can.
No,
I can take this one. I would say yes, but there's interesting things like when COVID hit, everyone thought that bankruptcies would just, the filings would just rise, and there would be an explosion of bankruptcies. And that didn't really happen because there was just so much equity infusion for people to restructure out of court. So it kind of depends on what type of recession. But I would say generally, yes, we are busy when the economy is bad. And when the economy is good, I switch over to my lending transactions cap and do that on the front end.
Yeah, and I'll say, even if, so when I was at my firm, I was doing just pure like bankruptcy, in chapter 11 in court. So I wasn't able to flip onto like more like pro-cyclical practice groups. But the great thing about sort of this counter-cyclical practice group that bankruptcy is that when the economy is ripping and all the M&A and cap markets groups and everybody else is doing wonderful, and the firms like bumping up salaries and bonuses and stuff, they don't really mind if bankruptcy is quiet. They're like, all right, we're all good. And they'll keep on paying the bankruptcy lawyers because they know eventually the cycle will flip. And when the cycle does flip, then the bankruptcy people are kind of viewed as like, oh my God, like we must protect them at all costs. We must retain all costs. Like, they're the only ones keeping us as a firm sort of like alive and posting numbers, period. And, like the other practice groups might start sweating a little bit like, oh my God, I have to hit my hours and everything. But it's kind of a nice thing. You feel a lot of like market stability in this capacity.
Yep.
Yeah, that's how
Microwave dinner time.
Enjoy your dinner, guys.
I heard it.
Absolutely. We'll let our panelists go to dinner. And again, they left their emails. So if anyone has further questions, please feel free to reach out. Thank you again for being here. And thank you to
for
the
having
audience.
us.
Thank you.
Thank you so much.
Bye, everyone.
Night, everybody.
Good night.